Good morning, everyone, in the history of the U.S. Constitution. I thought I'd segue from the area that we're in about basically post Reconstruction and get away from sort of government structure and the meaning of the Constitution as terms in terms of the power of the presidency, the legislature, and the courts, judicial review, and in the structure of how government's power will be interpreted through the Commerce Clause in the expansive role that government will deem to be had under the Necessary and Proper Clause. And we did cover the issue of slavery and the ramifications of the Reconstruction Amendments to the United States Constitution, that the 13th Amendment ends slavery as a legal protected practice. In fact, it's banned. And the 14th Amendment makes many of the federal principles applicable to the states now. No state may deprive its citizen of due process of law and the equal protection of law. And over time, that gets interpreted to mean basically there's a federal standard upon which the states can never go below over concepts of due process and fundamental fairness. And it really expands the power of the federal supremacy over states interfering on some of these what we consider to be unalienable rights. And then we know the 15th Amendment made clear that the states may not interfere or impede the ability to vote based upon race for males. And we know later the 19th Amendment will do it for women's suffrage. Later there's an amendment, I believe it's the 26th Amendment. I could be wrong on that number. I'm just throwing it out there, but it was late 1973. And that is no state nor the federal government could bar 18-year-olds from voting. Prior to that, it was a mix between the federal and the states, that some states were up to 21 and so was the federal government. But because of the Vietnam War and so many people under the age of 21 were participating in it, they amended the Constitution. But we're at this crossroads now. We can get into some material about industrialization, the freedom of contract, when the government tried to do some certain things under the FDR's administration to spur the economy. Much of what they did was often pushed back from in the early inception of our New Deal provisions. They said the federal government doesn't have the power to do it. FDR, the president, and Congress were on the same page trying to create the public works projects, certain agrarian subsidies to help bolster prices in the agricultural realm, which was suffering significantly during the Depression. And the Supreme Court says you don't have that power. And we can get into that in great detail, but this course is running out of time. And I think what's more fundamental, if I think I see you, hopefully someday live and in person at a graduation, and you're walking across the stage, and I know you took constitutional history, what's more important than some of those economic interpretations of the power of our government to participate in? I think it's more important to know civil rights and civil liberties. And so I want to segue now into the amendments. And I'm going to skip a couple of the Bill of Rights and a couple of the amendments to the United States Constitution, simply because we only have so much time. So I'm going to go with the big core aspects of what I think you need to know as a citizen. Second Amendment, I'm not saying it's not important, the right to keep and bear arms. That's in some flux. We know no right is absolute. But as a general principle, the Second Amendment has meant, even though it suggests it's about being armed in a well-regulated militia, it's actually meant private ownership of arms on some level, and the courts have interpreted it to mean that. Some of you are doing papers on that topic, and that's fine, but I don't think we're going to spend a lot of time in terms of requiring you to go over the Second Amendment materials. And same with the Third Amendment. That's going to be about quartering of soldiers in private homes. It just doesn't come up anymore. In the Seventh Amendment, it's about the right of individuals to seek a jury trial in most civil cases. That's important, but it's not critical to fundamental civics, right? The Ninth Amendment is very important. We'll talk about that a little bit, but it's not as nearly important as some of the other amendments in the Bill of Rights because it's largely been ignored in the big picture by the courts. And basically that amendment is clearly suggesting that just because we list certain specific rights in the Bill of Rights as protected against government interference and government protections, that doesn't mean others didn't exist. And whatever did exist is still retained by the people. It's sort of a catch-all, and it's been used occasionally. One of the famous cases was over contraceptive rights of women. I think it was in the late and that was in the early 1970s. Contraceptive was illegal even with a prescription from a doctor for women back in the 70s. And this woman down in Connecticut purposely violated the law as a test case, if you will. And she got charged. I think she got some kind of fine. So she appealed it all the way to the Supreme Court, saying that as long as I have a prescription from a doctor for prescriptive drugs, the government has no interest in interfering with my reproductive rights. And that case used the Ninth Amendment to say there are certain inherent privacy interests that the government really shouldn't delve into. And even though they're not listed anywhere, the Ninth Amendment suggests that's one of them, the right to fundamental privacy as to the reproductive decisions that women might make. And that was a famous case called Griswold out of Connecticut. So the Ninth Amendment is important, but it's just not used that much. And the 10th Amendment is not about civil rights as much as it is about states reserving certain sovereignty to make decisions within their own sphere of influence. And we know that was largely settled by the Civil War. States do sometimes have sole jurisdiction over certain legal and other areas of jurisdiction, but we know it's significantly limited because the 14th Amendment is one of the big results of the Civil War and basically limits the state's ability to curtail citizens' rights within their states that doesn't comply with the federal standard of the Bill of Rights. And that's where we're at. So let's talk about the First Amendment. Today, I'm going to break down the first part of it. There's so many rights within the First Amendment. And if I think of one, you argue, you have a round table and say, pick one amendment that's more important than the others. It's a terrible way to conduct an academic scholarly discussion. But there is, the one that would jump out at me is the First Amendment because it's freedom of speech, and related to that's freedom of press. We're going to break it down into probably three parts. One is freedom of speech. The other is freedom of the press, which is very related. But then the other, really two, is freedom of religion, the exercise of religion. Then the barring of what we consider church and state, that we can't formally recognize a state-sponsored religious practice. And so that's called the Establishment Clause, freedom of exercise in the Establishment Clause. So there's two parts. And then there's the third one, really a fourth one. There's multiple rights in the First Amendment, and that is the ability to petition and assemble in protest against your government. And that's fundamental to First Amendment. So what are we going to do on the First Amendment, freedom of speech? Let's talk about it. Do we have the right to say or do anything we want in terms of freedom of speech? It says Congress shall pass no law. Read the amendment limiting the speech of the citizens of the United States. However, what we know is all rights, none of them are absolutely protected. There's limitations on every right. Think about it. It makes common sense. If I'm free to say anything I want, then I can go out and libel and slander people I don't like and hurt their reputation and hurt their standing in the community and maybe even get them to lose their job based upon lies. We don't want people to be able to do that. I could also endanger people by the old classic line. I could be in a movie theater. Let's hope someday COVID's gone and we go back to movie theaters. But in a crowded movie theater to shout fire, that would cause imminent harm to human health and safety because everyone rushed to the exits. I guess in today's modern world, if I shout he's got a gun or she's got a gun, that might be equivalent to it when in fact that person doesn't have a gun or there is no fire, because it causes fear of health risks. Now, careful. There are also something called fighting words. This one's a little bit more controversial. Fighting words, the government does have an interest in limiting, in that if words are likely to trigger a violent reaction in the recipient of those words, then the government has an interest in curtailing it. The courts have had a hard time interpreting what are exactly fighting words, but if they can articulate it, then they can basically limit our ability to use them. I just think the court has a very difficult time on articulating exactly what are fighting words. Offensive speech is protected speech. We cannot and will not, as a free society under the First Amendment, limit speech that we determine to be offensive. Offensive speech is protected. And I'm going to give you some cases to look through, and some of you are surprised. One is the West Baptist Church, and that came down maybe within the past 10 years, certainly. These people would go out and protest at the funerals of service members who died in defense of our country or as service members, and they would say really, really inappropriate things from public spaces. That basically your child has died and God is happy because of certain things that are going on in our society. Clearly offensive. but is offensive speech protected? And the court ruled 8-1. Only one justice, who's still on the bench today, Justice Alito, said this is so offensive and so unredeeming of any value that it should be curtailed. But the other 8 members said, but it's about social and political and philosophical views, and it's done from a public forum. These people are in public ways when they were doing it. It's protected. And I think most of us, deep down inside, when we recognize that if the government was able to pick and choose which offensive speech could be, squashed or chilled, it may be used someday, that it has a political view that you think is very important. And if the government had ability to put a chilling effect on it, we'd live in a totalitarian society. That's probably the thing that really keeps us free, is the ability to protest and say things that are contrary to maybe what is popular at the time, because sometimes those that are in dissent today will sway public opinion in the future. And people should be able to speak their minds freely about almost any issue there is, as long as it doesn't violate these other principles. And what are the other principles? Clear and present danger. That's the standard we have now, that it's likely to trigger violence against the government's interests, the people's interests. That's related to fighting words. The other, sexual harassment. You can't say things in the work environment that makes people feel uncomfortable, either because you're looking for quid pro quo. You're basically saying in order to stay in this job or to get a promotion, you have to date the boss, things like that. That's sexual harassment. That's related to speech. That kind of speech can be sanctioned and punished in silence. And the other is just basically outright sexual harassment, creating a sexually hostile work environment because of the things you're saying and or depicting in photographs or in imagery and things like that. So we know that's banned as well. The big one I really want to get you to is, well, that means we can pretty much say most things. Speech is not only words, it's also depiction in video and in art and symbolic speech. Is that speech protected, meaning that we're free to keep that? Yes. Does the government have any interest in curtailing it? Yes. The only one they've been successful in defining as being able to curtail is those that create clear and present danger. I put out a pamphlet and I mail it to people and say, get your guns. We're going to go up down to Washington and we're going to take over the government. That might incite violence. That's called clear and present danger standard. Oliver Wendell Holmes, in a dissent, actually created the standard that gets adopted later in the 1960s. So you're pretty much free to say anything anti about the government, but if it's so elicits and is a catalyst to actual violent overthrow of the government, it can be banned, and you can actually be punished under sedition law, because the government does have an interest in curtailing speech that would trigger violence against people and institutions that we hold dear to us as democratic institution. But can I burn the American flag? Yes, I can, if it's my American flag. But people say, well, people are getting arrested for tearing down statues. That's because they don't own the statues. They're not being torn down over the content of their viewpoint. But if I owned a statue of, I don't know, some Southern military leader, and I'm outraged over the fact that this is maybe arguably got some kind of racist overtone or supportive racist ideology, I could tear it down and burn it if it's my statue. Just like I can't go and burn down the American flag at the post office because I don't own it. But could I burn the American flag here on my own property? Yes, because it's symbolic speech, and the government really doesn't have an interest in curtailing that, because no human life or health and safety or property of others is being damaged. And some people find that very outrageous, and I'm one of them. I have political buttons back here, but back in my house where I grew up in Springfield, my mother still lives there and she's still alive, and my bedroom's still there as it was when I left it. Sometimes I wish I was still there. But there's a big American flag in there with 48 stars, because my father and I love history and all this stuff. So 48 stars before Hawaii and Alaska came in. I love the American flag. I honor it all the time. I take a great deal of pride in it. But do I recognize that others may use their symbolic imagery to burn that? And should it be protected? I think it should be protected, not the flag. I think the symbol of the flag should be respected for me personally. But does that mean, do I mean other protesters shouldn't be able to go out and burn it? Yeah, I find it repugnant. I find it disgusting. But should it be protected? And the court says, yeah, that symbolic speech is protected. But the biggest test I want you to realize that's out there is that if it's not going to incite immediate harm to property or persons, the only other time the government really has an interest in curbing speech is when it's going to be damaging to health and human safety. And that one is sexual harassment. That's one I brought up. The other is also libel and slander. The government will sanction you if you tell a knowing falsehood about another individual, called publication. When you hear publication, I think it has to be in a newspaper. But no, I tell other people. I put it on Facebook. they could sue me for libel and slander. And all they have to prove is that the statements were a material misstatement of fact. It's going to be fact. I can't say this person's a jerk or they're a loser or they're immoral. Those are opinions, and that opinions are almost always protected. But what if I say that they're a convicted child molester? If they're not, and I know they're not, and I disseminate the information and they lose their job or they suffer emotionally, they can sue me for libel and slander. So not all speech is protected. We allow people to sue when they've been libeled. Now, one of the big distinctions, and I'm going to have to test you on it because it's very important, public figures, politicians, actors, people that are in the forefront of having a public persona, if they have facts misstated about them, they can't sue unless they can prove something called actual malice. So say I'm a newspaper and I write that, Donald Trump raped some woman. And Donald Trump gets very upset and he sues my newspaper and me, saying that I've libeled and slandered him. He has to bear a very significant burden, not him personally, but any political figure would have to prove that I knew it was a lie and I still publish it. Mere negligence isn't enough for public figure libel and slander. I would have to know it's not true. But if I heard of an allegation and I reported it, that speech would be protected. And that sometimes dissuades certain people from getting into public life, because people will say things that are very negative about them, and there's very little ramification you can do other than insisting upon clarification or trying to put people to their proof. And there's certain protections for certain other public figures that say things in the role of, like, judges and lawyers are protected in a courtroom. Even if they say misstatements of facts, they're protected under a special. Well, don't worry about that. But the real crux of what people sometimes get surprised about is the government does have an interest in limiting certain speech in time, place, and manner. So imagine if we're in class today. It's 9 o'clock in the morning, and we're in class, and I'm doing a little discussion about some famous case called Schenck, which is really probably no longer allowed. I'm discussing, and all of a sudden you start protesting over the Affordable Care Act, and you start chanting, Medicare for all, and you're talking over me. Can I kick you out of class? We're a state institution. I'd be basically the government squelching your speech, and you're speaking about a political issue. I thought you're going to say, Jim, it's free speech, freedom of speech. But we can control it in time, place, and manner. You're interfering with the clear objective of what the educational institution is there for. Although a state institution, therefore the state could be sanctioned for violating your free speech rights, but not unless it relates to reasonable time, place, and manner standards. So the school often has common areas and things like that. You should be able to protest and do whatever you want in the common areas at a reasonable time. So you shouldn't be able to be there at 1 o'clock in the morning. Just like if I'm in my neighborhood and I want to have a march and I want to protest something or promote something, I might not be able to do it on the main street during rush hour because it's going to impact traffic. Careful though, when the government, have they misused the tools for time, place, and manner sometimes to put what we call a chilling effect on speech because the government doesn't like it? Yeah, they have. They've done that to many people. The Southern, it's not the Southern, it's the civil rights movement, but let's face it, much of the conduct of the activity of the civil rights movement was done in the South in the 1950s and 60s. And when they were doing that, they would say, okay, you want to have a march from such and such or do a protest from such and such, you have to hire X number of state troopers to come and make sure that it's safely done, and you have to have a permit. The permit costs $500, and you have to have a list of all the people that are, to really make it so onerous. Is that really a reasonable time, place, and manner restriction, or is it designed to basically squelch the speech? And those are the kinds of things we have cases over all the time. Generally speaking, there are differences in the different context, place. So, for example, in schools, there's some famous cases which I'll post and ask you to read about. And I'll give you a summary from some articles that have written it much better than I did about what kind of limitations are different in different contexts. So, for example, can I go out and advocate that, smoking marijuana is great for everyone? Yeah, probably be protected in the right area. But what if I was a high school teacher or a high school student? Could I put that in the school newspaper and all of a sudden the editor, some teacher says, I'm going to redact that. Now I sue under free speech because, smoking of marijuana is a reasonably appropriate, but it should be protected speech in most contexts. But the school purpose is basically trying to educate and inculcate people from not using illegal drugs. Well, marijuana is now legal, but it's not legal for underage people. Say it was heroin. They could ban that kind of speech because it is in direct contravention of school policy and it interferes with their philosophical outlook of trying to promote lack of illegal and illicit drug use. And that there's a famous case in it. But what about these kids in the 1960s or early 1970s that were wearing black armbands to protest the Vietnam War? These students got suspended and punished, and they sued. They said, that's our free speech. The school lost that. The students won. Why? Because wearing a black armband to protest the Vietnam War didn't interfere with the functions of the school in any way, didn't interfere with the educational goals and pedagogy, if you will, that the school was trying to promote. So you can see the kind of balance they're trying to strike on letting as much speech be discussed, but without being, well, I hate to say it, ridiculous. And there's a famous quote by one of the justices, I think it was Justice Jackson back in the day. The Constitution is not a suicide compact. There has to be reasonable limitations under certain circumstances. So time can't necessarily protest at unreasonable hours. Place can't necessarily interfere with traffic and things like that, or the educational pursuit of an institution, or say we're at the courthouse. Can you start protesting in the back of the courtroom in the middle of a trial? Of course not. That would be inappropriate. It interferes with the function of the judiciary at the time. But could you maybe protest out in front on the street during a reasonable period? Yes. And manner. How are you going to do it? If you're going to burn a giant effigy of the President of the United States, could that cause a fire to spread to buildings and things like that? That kind of speech might be curtailed because it's unsafe in the way you're doing the symbolic speech. Same with if you had a bullhorn and you want to do it at 3 o'clock in the morning, you might be disturbing the peace. And so it's very interesting. But I want you to focus on the time, place, and manner. Now, the other kind of speech that could be curtailed, we talked about sexual harassment too. It has to be unwanted. And it has to meet both an objective and subjective standard, meaning the victim has to subjectively feel offended by it, and it's got to put a chilling effect on their ability to function or work in the environment. But it also has to be objectively offensive, meaning that is this person really, if somebody comes in and say, hey, I see you got a new haircut, it looks really great, and that person goes, oh my God, I'm being sexually harassed. Would that be a reasonable, objective type of thing? And that's what the court has to, and that's what the trial's for. But they have to meet those standards. We don't want to put too much of a squelching on speech that doesn't have an objectively detrimental impact. The other big one is obscene speech. Obscene speech can be barred. And what is obscene speech? And this is the big test material. The courts wrestled with it forever. They're still wrestling with it. And what I'm talking about here is pornography usually. That's what we mean by obscene. Offensive speech, protected. People can be offensive. They can't be obscene. So what does it mean to be obscene? And most people think, well, obscene is not what you personally think. The courts crafted a criteria for determining what is obscene. It's called the Miller test. Why is it the Miller test? It's a famous case called Miller. And it's been evolving over time. There was a different case that had 5 prongs before. Now it's down to the 3-prong Miller test. And I'll tell you, the court still wrestles with actually applying it. The first test is that the material has to be designed to only appeal to the prurient interest of the observer, listener, recipient. Prurient means sexual. It's only designed to appeal to the sexual interest of the listener. It has to violate the community standards upon which it is being disseminated. That's a very difficult one. But the argument is we have different community standards, whether you're in, Worcester, Massachusetts, or if you're in Selma, Alabama, there's different cultural values there. I don't know how you apply that test at all. I don't think the court knows how to apply the test. And the third one, the one that I find debate about all the time, is it doesn't have any other social, scientific, or artistic value whatsoever. Is the court expertise in determining all 3 of those elements have been established? Courts have a real tough time with it. In fact, one justice said, hey, when something's obscene, pornographic, you know it when you see it. What's the problem with that standard? You know it when you see it, according to whom? It's a very tough thing. I can tell you there is one clear one. What's one thing that's clearly subject to government banning? Child pornography. Because there's enough scientific data to know that the depiction of people under the age of consent, depending on what state you're in, usually it's 18, the majority are an adult at 18, those individuals depicted in prurient forms of expression, that can be banned because it's deemed detrimental to society as a whole. Outside of that, they've had a really tough time doing it, and that's why most what we consider to be adult uh, depictions of sexual behavior have largely been left to very little government structure, except for time, place, and manner, meaning that we don't want juveniles to look at that material, people under the age of 18, and we don't want it basically freely accessible necessarily. And the problem is every time the government tries to come up with a rule that you can't depict it on this kind of thing, you can't depict it on that kind of thing, the government's had a very tough time. Same with speech. Every so often someone will come and say, hey, Cambridge not too long ago, Cambridge Mass tried to come out with a rule that they're going to prevent profane speech, swearing. And, people are walking up and down the street saying all kinds of this word and that word and everything else, and it's really upsetting people. That got shot down before it ever got enacted, because the reality is every time the government tries to come up with codes of appropriate speech, it's always been shot down as unconstitutional, because it's so difficult to define what's obscene versus what is offensive. And guess where we're at? We're in college, right? Do they come up with codes of conduct and speech to make people feel more comfortable to college? Yeah, I'm all for it. We don't want people saying offensive things that might make certain, identities feel unwelcomed, whether it's sex, race, color, creed, sexual orientation, age, all of those things. We don't want people to feel, I'm not welcome here. I want to feel safe emotionally. I'm all for it. But the reality is when they try to create a code and then enforce it when somebody says something that offended you, when challenged, all of these colleges, they've never been successful in the challenge. It's just so difficult to distinguish between that kind of a speech that can be curtailed and that which cannot. And one of the things that I find very interesting, I'm very concerned. My kids are getting a little older now. I only have one kid really in grade school now. He's in ninth grade. I always worry about kids being bullied. And some of the bullying, let's face it, is what? Is speech. And if somebody comes up and says to my kid, hey, you're so skinny, you're so tall, you're so whatever it is, and then, and say, I get upset as a parent and say I report it to school, and the school tries to sanction the kids that are saying bad things to my kid. If those kids get suspended or get punished in some way, I think they would have if they were willing to spend the money and go through the process, I think bullying codes which relate to speech are suspect to being overturned as a violation of the freedom of speech. I think we're free to speak our minds about offending people. And that's a fine line. And that's part of democracy, is it's not always, wonderful, the outcome of it. But if we start putting chilling rules on speech, it's a slippery slope. And I think that's what the Constitution's afraid of. We'd rather have wounded egos and wounded experiences as opposed to taking away the concept of free speech. Now, there will probably become a dichotomy at some point, a distinction between that kind of speech that goes on in schools, especially schools that are underage, versus adult form learning in colleges. But it's a fine line, and it's very, very difficult. So I'll put some information up there about this free speech. You need to know there are limits on it. But generally speaking, in terms of pure protection, the one thing the government really has a tough time cracking down on, and I think rightly so, speech should be protected, because the free flow of ideas, the free flow of debate should not be fearful. It should be out in the open, and let's have bigoted people be revealed as bigoted people. Let's let stupid people that say stupid things be revealed as stupid. But if we punish them simply for saying thought processes, I think it's a very, very dangerous slope. I'm trying to think of some of the other aspects. I'll put up some critical cases that I think are important, assignment related to them. I don't want to kill you. The semester's going to start really hustling, but I'm going to also put up, those of you that don't like reading the long technical cases, I think they're fun, but I'm a lawyer, been practicing a long time. Case law is tough if you're new to it, and you should feel comfortable with being uncomfortable reading case law at this stage. Don't feel bad about it, but I'm going to put up articles that explain the cases that I'm going to ask you to read. So if you read the case and say, I'm just not getting this, this Schenck case, or I'm not getting this Tinker case, I don't get it at all, I'm going to put up articles that tell you what those cases mean. So when the test comes up, you shouldn't have any real excuse for not understanding the concepts under freedom of speech. The next thing I'm going to put up are two different prongs on freedom of exercise of religion and the Establishment Clause, which bans the government from establishing a religion. Careful, it's not a thick, impermeable wall. There is some overlap. Like people say, we can't say a prayer at the opening of a school ceremony or something. It's not true. And can't do a Christmas play and reference Christmas in it. Not necessarily true. But anyways, we'll get to that soon. Don't be afraid to reach out and ask questions or raise concerns.